Yeah.
Well, it's my less fortune, but hopefully the opportunity will come and I will get to meet you face to face. But I'm happy to collaborate with you in this competition.
Pleasure is all mine, Mr. Sherif.
Good evening, everyone joined here. I just want to confirm the judges has got your score sheet, right? Just a confirmation.
Yeah.
Thank you. A warm good evening to all of you joined here. My name is Vismaya and I will be your session observer to the much anticipated finals of second international mediation competition jointly organized by His Highness the Maharajas, Government Law College, Ernakulam and Lex Erudite. Thank you for joining us. Let me introduce the panel of juries, the energetic panel we have today. We are having Honorable Justice Devan Ramachandran, Judge, High Court of Kerala. Honorable Dr. Sherif, Chief Judge, Cairo Economic Court, Egypt, and Mediator of the Global Mediation Panel of the Office of UN Funds and Programs at United Nations. And Professor Dr. Bryan, Advisor, Lex Erudite, Patron of IMC-V-2022. We are fortunate to have such a great panel of judges. For the session, we have the team IMC-222 and IMC-228. Client and counsel from IMC-222 will be representing Plus Builders, and client and counsel from IMC-228 will be representing Vantley Developers. So all are ready? Yes, I can see a lot of heads up. Let me read out the rules and regulations given to the participants. I know all of you are well known about this thing, but still it's a part of our introduction. Participants are requested to follow the rules and regulations. The total duration of the session is 1 hour, that is 60 minutes, wherein 50 minutes for mediation and 10 minutes for judges to give out their remarks. The mediation session also includes a maximum of 6 minutes, which should be allotted for the mediators, that is joint mediators, for opening statements. A maximum of 4 minutes each will be allotted for the negotiating team for opening statement. There will be 1 caucus per team, maximum 5 minutes for each team, which can be requested either by the mediators or by the party. The participants, please be alert of the chat box. The room administrator will notify at the end of 5th minute and also at the end of 3rd minute for opening statements. That's all the rules and regulations for the final. I hope I'm clear. Everyone? Yes, you can see a big smile in the participants, please. So is there any clarification needed? I guess no, because everyone is really excited, just waiting for to start the session, right? Yes. If the judges could give us heads up, we can begin the session. Yes. Now it's time to begin. I welcome the mediator to take over the session. All the very best.
Hi everyone, my name is Dena and I'll be one of your mediators for today's session.
Hello and good evening. I believe everyone present here is safe and healthy and doing all right. I'm Shubhi Vyas. You may refer to me by my first name, Shubhi. I'm here in the capacity of a mediator. Thank you for choosing me as your mediator today, and I extend my appreciation to both the parties for agreeing to this alternative mechanism of mediation in an online format. To start off, may I request all parties present at the table to kindly introduce themselves and tell us how should we refer to them. Also, please confirm that you have the full authority here to make decisions and representation. May we start with Vanley developments.
Greetings to all. I'm Veronica. I'll be representing Vanley Developments here in the capacity of a client, and I'll be represented by our counsel throughout this mediation process. At the very outset, I'd like to mention that I have the full authority to settle the dispute here. Thank you.
Thank you, both the mediators, for allowing me to speak. Good evening, everyone. I am Peter Stringer, the in-house counsel for Vanley Developments. You may address me by my first name. First of all, I would like to disclose that I have the full capacity to be a part of this proceeding in my ex officio authority and have no conflict of interest that materializes. Thank you.
Good evening, everyone. My name is Devan, CEO of Bluth Builders. You all may address me as Ms. Bluth.
Good evening. I am Sam Ruffle, representing my client, Devina. Thank you.
Thank you, parties and counsels, for introducing yourselves. And I would like to extend my admiration to both the parties for coming to mediation. In fact, all are at this virtual table shows your inclination to drive a common resolution. Now, I would like to quickly acquaint you on the process and structure of mediation. Mediation is a voluntary process, and the participation of both the parties here is voluntary. And whether you choose a resolution today is up to you as well. It is a flexible and neutral process, and our role as a mediator is to facilitate your conversation about the matters and issues that disturbs you. We do not tell you what to do, nor we judge what is right or wrong. But we are here to guide you, make your conversation go smooth, thereby getting you the best resolution. Also, I would like to explain you the confidentiality clause involved in this process. Anything you say in this room remains within here, and nothing is going to be used against you. So you feel free to come to the issues that are worrying you and find a resolution, thereby settling the process amicably. Now, I would like to pass the time to my co-mediator to describe more about the various processes involved, rules for parties, and set the ground rules and expectations for today's session.
First of all, I'd like to thank the parties for their introductions, and I'd also like to thank my co-mediator for touching upon the mediation process. I appreciate the understanding of both the parties that they know the importance and urgency of conflict resolution. We hope that this session turns out to be a productive one and the parties reach a consensus that is mutually beneficial to both of you. I believe that both the parties have agreed to follow the ICC mediation rules for this session. My role today here is that of a facilitator in the entire process. We as mediators here won't tell you what is right or wrong and would neither suggest or advise or give solutions. What comes out of this mediation session is totally up to the parties. This mediation session is different from courtroom litigation. We are here to make sure this session goes on smoothly and to discuss the core of the issues and reach some mutual solutions. I encourage you to be open and frank and adopt a forward-looking approach to reach an agreement. Feel free to use the time and process to explore any ideas or concerns that you may have. As you may know that this mediation is a confidential process, consider it as a safe container. Another thing I would like to flag is that I, as a mediator, will be impartial and neutral. I don't want to see either party win or lose. We just want you to have a conversation and come to an agreement that you both are really happy with. Throughout the session, if at any point you feel that you need to have a break or just a private session with either the opposite party or the mediator, you may call for a caucus. In the caucus, there is another layer of confidentiality added. Whatever is being conveyed to us in the caucus will remain confidential until the parties allow us or expressly disclose the information to the other party. Also, to make sure that we utilize the session to the best of our abilities, I would like to inform you that this session is of 1 hour, and I suggest that we could reserve the last few minutes to go over and sum up whatever has been discussed and agreed to ensure clarity and avoid confusion. The ground rules are that the parties must be respectful towards each other and should not indulge in any verbal abuses. Also, make sure that you keep your microphones on mute when you are not speaking. If you have no further questions, we may proceed to hearing your opening statements and setting the agendas for the day. I would request Vandelay Developments to go forward with their opening statements.
Well, first of all, I'd like to thank the mediators for explaining the process so well that I was able to clarify all my doubts. And secondly, I thank Blood Builders for agreeing to go for mediation, as it shows the tenacity towards resolving this dispute. I agree that the onus of COVID-19 cannot be placed on either parties, as it was unforeseeable for both of us. We could not have anticipated what was about to come. And that's why we will try our level best to be as flexible and understanding towards your concerns. However, we wish that you reciprocate in the same way, in the same manner. I hope that we will certainly be able to come up with certain fruitful solutions that is in the best interest of this project and for both the parties. The agenda will be discussed by my counsel. Thank you.
First, I would like to thank both the mediators for the thorough explanation of the process. I would like to clarify that today I am a part of this session only in an advisory capacity, though I would be the one who would be negotiating on behalf of my client, but all the pertinent decisions would be taken by my client herself. I think it would be in the best interest for both the parties to articulate their own perspectives instead of getting tangled into legal quagmire and technicalities of the matter. We should nonetheless bear in our mind that this session is occurring under the shadow of the law, and should we stray too far away from the primary interest or objective of this session, both the mediators would help redirect us. At the outset, the representatives of Blood Builders and Company, we really appreciate you coming here and to be a part of this mediation session to solve this issue amicably. This signals a desire on part of both the parties to move forward instead of dwelling upon the past losses and reach an amicable and mutually beneficial agreement. You taking out time to reconsider the dynamics of this very important relationship is reassuring, and I hope that we will be able to capitalize upon this opportunity. What my client and I seek to achieve through this session is that both the parties have a discussion in a manner which hasn't been possible so far. As highlighted by the mediator, while the proceeding remains confidential, we should all be open and transparent with each other. I also request the counsel for Blood Builders and Company to sign a confidentiality agreement after the session is over. Our goal today is to maximize the mutual benefit to both the parties rather than dwelling upon the past losses. For us, the resolution of the following issues is key. The first one of them being completion of project within the stipulated time. The second being completion of work within the previously decided budget. And the third and the last one being about the specifics of release of prepayment. And to maintain amicable relationship and to finish this project, my client is willing to negotiate and be flexible with the opposite party. While this entire chain of events has brought bad press to my client in the course of the dispute, or owing to the collaborative nature of the proceedings, we still hope to come out of this session with the best possible outcome. Thank you.
So thank you, parties, for a very clear opening statement. And if I would quickly summarize a few things that you have talked about, you actually wanted to have built a very good relationship with Blood Builders and Company, and which is a very good decision from your part. And what actually you expect out of this mediation is that the completion of the project on time, and and to further maintain a good relationship with both the parties. Does the parties have anything to add on to this?
Yes, we also mentioned two more agendas.
I believe
completion of.
I believe I can sum that up for the convenience of both the parties. So I believe the three agendas listed by Vandelay Developments were, first of all, the completion of project in time. Second was they want to get the project completed on previously agreed payment. And the third one was regarding the prepayments involved within the projects. Is that all right? Yeah, all right. I think we can proceed with the opening statements of the other party now, if that's okay with everyone. Yeah.
So we, Blood Builders, were appointed as the main contractors by Vandelay Development for a construction as well as fitting of all the interiors. The commencement of the project as per the contract took place at Jan 2020 for a total price of 200 million piastres, with 50 million piastres paid at the beginning of the contract. and the rest paid at the beginning of each year in 50 million piastres. The project was calculated to completed by the December 2022. The work that had begun was halted by the end of June 2020 because of the COVID-19 outbreak. The site had to be evacuated as all the functions came to break off for a period of 9 long months. Since the international travel was also ceased, we could not make it to Ichana from April. When lockdown ended and work began again in the beginning of March 2021, an amount of 50 million piastres was paid with agreement to an additional 9-month period for the completion of the project. It is also to be noted that the partially completed work was subjected to extreme vandalism. It took us 3 months for only the remedial works to be carried out. On January 2022, we were at a position to estimate that the completion of the project could be only by the end of December 2024, and also requested for an additional payment of 75 million piastres. The first and the foremost reason for such a request is the unforeseeable situation that we had been facing from the past 1 year. The pandemic, as all of you are aware, as it has affected all the businesses globally, making it hard, especially for our industry, for gathering the manforce and the machineries required. At this point, Vandelay was incensed and responded that no further alterations would be made to the conduct of stating that it was a breach of contract. But let me ask, how can Vandelay claim the alterations in payment or date of completion be a breach of contract when they agreed to the new adjusted date of completion on March 2021, but as of now, making that kind of alteration seems to be a breach? I refer to my counsel who would be further enlightening you all on the legal aspect.
Good afternoon. I'm Sam, Counsel of Miss Flight. I would like to thank the mediators for setting such a friendly atmosphere here, despite the circumstances that we are facing right now. I'm sure that with your guidance and expertise, we'll be able to reach an amicable solution. I want to start by reassuring you that my role here is purely advisory, and I'm solely here to bring clarity on the issues discussed here today and to aid in finalizing the statements and the issues discussed throughout this mediation. I would like to emphasize how impressive Miss Blight's willingness to be open and honest despite the events that have led us to being here have been very difficult to my client. My client has not come this far and attained high level of success by dwelling on problems. I have faith that you too will share my client's collaborative spirit and that this issue can also be resolved. My client understands the nature of the contract has changed in these extraordinary circumstances, and she believes that it is essential for the continuance of the agreement that certain changes be made into it, and the project can be brought on track. Ms. Blight wants to reach a settlement agreement that satisfies the future aim of both the parties present here. As Ms. Blunt's counsel, it is due my position to explain some of our basic interests. In that regard, we have 3 main interests. The first being that my client would like to continue the contract, that is after certain alterations are made. We would like for a period of 15 months to be extended and also for an increase in the overall contract price. Secondly, we would like a public apology from Ms. Veronica recanting her statement that she made at the International Association of Builders. Thirdly, my client also wants compensation for the damages that is caused to her reputation that resulted in several future contracts being dropped. First and foremost, I'm an advocate for these interests. So in the process that this does persuade to arbitration, I've advised my client that I would persuade the arbitrator of how there was no breach of contract here as it was delay that occurred and not anything else. And it was due to the unforeseen circumstances that my client had to delay the time. And my client, due to the defamatory statements that Ms. Veronica made, is entitled to compensation from the injury that is caused to her company. I personally think that mediation should not be about legal arguments, but must be about the needs and interests of the clients and finding beneficial situation. That mediation is indeed the best option for solving this current issue, as it can provide both the parties with an understanding on what the underlying reason for the occurrence of these differences are and why each acted the way they did. I've personally encouraged my client to come here in good faith for understanding as well as value openness as well as honesty. I believe both of you are also in the same page and is willing to find solutions together with my client. Thank you.
Thank you so much. I'll quickly summarize the points from Black Builders. Basically, the agendas, the three main agendas were listed by the council. I'll just summarize them so that you can give me a nod if those are the only agendas that you guys have. First of all, you are ready to continue with the project if you are provided with 15 months of extension and the overall price is also increased. Second, you want a public apology to be issued by the other party. And the third involves compensation for the statement that was made by the other party that resulted in injury to the reputation of your client. Are these the only three agendas?
Yes, these are the only three agendas. Thank you.
All right, thank you so much. So after listening to both the parties, I've come up with certain common agendas that both the parties wish to address in this mediation session today. I'll just quickly list them so that I can get a nod from both the parties if those are the only agendas you would want to discuss in today's mediation session. So first one is the parties do want to settle the dispute mutually and in an amicable manner. The second issue is of the extension and the time limit of the project. The third issue is about the payment or I think prepayment can be a separate issue. So I think the third issue is of the payment, like earlier it was $200 million as you guys stated, and now you are requesting for it to be increased. The third issue is that. Fourth is that of the prepayment. Are these and of course, then regarding the public statement made by the party and the apologies, are these the only agendas that the party wish to discuss?
Public statement as well as damages for the issue discussed.
Yeah, the statement would cover the damages. Yeah, thank you. So,
yeah, if that's perhaps well with the parties, we'll move on with the first point in agenda, that is extension of time limits and the completion of the project. And the requesting parties, what do you have to say about the extension of time?
So basically, before starting off with anything, I'd like to set up the background as to what actually happened. We signed an agreement, we signed a contract with the Blood Builders as a contractor for the project. The timeline and installments were very well stipulated in the contract. However, due to COVID-19, it halted the construction work. When it recommenced, we agreed to pay 50 million piastras immediately and extended the time to compensate for the halt period, that is for the 9 months that we lost due to owing to COVID. However, we were actually shocked to see the demands put forth by the other side. Our major concerns include our major concerns are generally four. The first, that they demanded to extend the time period from 9 months to 15 months. That is, they will be completing the project by December 2024, which is like a too much extension being asked for. It's like a 1-year extension. And they need to understand that we are also constrained by the fact that this is a project which has to be let out to the other customers that we have. We have already entered into numerous agreements for hiring this venue. If we do not allow the parties to use this venue, it costs us around 30 million piastras. So that's why the completion of project within the time or whatever time being negotiated here is of utmost importance to us. Second, that they have to understand that this contract is not a let-alone contract. It doesn't exist in silos. We have another contract with the government. So that's why the time is actually of essence, given that we have to be answerable to both the government as well as the customers. And we understand that the leaving of project for a long period of time may have caused damage to it, but the contract stipulated that the project has to be secured by the builders. So if any damage has been caused to it, they at least have to provide us with the details. Then only we will be flexible to fix that. This also pertains to the case of increasing the budget or the installment payment. We need details because they already they just sent us a letter wherein they pointed out that certain external changes have happened and they haven't detailed out what actually happened to the project. So if we are provided with details and the outline of how they are going to proceed with the project, we'll certainly be willing to negotiate on that. And obviously, we want to continue with the project. It cannot be left midway. It's very difficult for us to find a contractor in just a short notice. So it requires a long bidding process. So time is actually of importance for us. Regarding the extension, my counsel will offer what he has to, because it's in my best interest, because whatever he's going to offer after consulting me. Yeah, obviously. Thank you.
Just a second before we go on into the offer, I think I'll just quickly sum it up for the convenience of the other party. So I think what Vanley Development here wants to say is time is of utmost importance for them, and they cannot give too much of extension as they have lended out the venues to other people. And this is not a let alone contract for them. They have the government involved as well. So if the other party is willing to provide details regarding the delay, I think they are willing to negotiate on this project. I think now we can proceed with the council.
First of all, I would like to add to what my client said, that in the contract it was mentioned, though it was an oral contract between or written contract between both the parties, it was mentioned that the builder would do weatherproofing of the building before leaving the site, before the commencement of the lockdown. So there was a clear lack in a proper weatherproofing, which also caused damage to the building. And also the second point which I would like to mention is that the builder was the one who was responsible to make security arrangements so that there's no damage to the building. And the suspected vandalism which occurred at the building, so it cannot be just accounted upon my client. So there is a negligence on both the parties that damage has occurred to the project. So before providing any offer, I would like to hear the other side first.
Yeah, the other side.
So as per the request of Ms. Veronica, I would like to explain one of the main reasons for the increase in cost and time. That is, the component we use in our build is titanium, which is a material that leads to very high energy efficient builds. Because of political pressures and environmental damages, there has been a new levy that has been imposed for the excavations. The excavations are done by block builders ourselves. And this has greatly increased our project costs, and using another material would compromise the integrity and efficiency. As far as I am concerned, we do not want to compromise on the quality of the building for reducing the cost. The supply chains of the materials and labor has also been severely disrupted by COVID, and it's not fully recovered yet. It has also been hard to get and keep reliable laborers. I would like to mention that for the rest of the work to be carried out, we require extensively technical machinery.
Well, if I may be clear on what my client said, because of these constraints that we would like the price be increased, because what happened was not within our reach. It was an unforeseeable event, and it was because of the government that happened. And also it is very hard for my client to find labors and new routes for getting the raw materials because of these restrictions that is imposed by coronavirus pandemic. So it is also because of that we would like an extension period, and also an amount of 75 million also.
To make it more clear to the other party, what the council and clients of blue builders are trying to convey is that they actually tried not to compensate the quality of the building they are being constructing, and so they tried with another product for the quality of assurance. And also, as we all know, the pandemic has affected everybody. So the supply of raw materials for the production of the continuance of the work was also in delay. So that's what they are trying to convey, that the supply of things was also got in delay.
Also, just to add on to this, I think they had two more points, that using this material is costing them more than usual. And there is they need extensive technical machinery. That is why they're asking for the increased amount, right?
Yeah.
So both the parties are willing to negotiate on this matter right now, right? So should we go into the offers that any of you have to offer?
Okay, so first of all, I would like to extend an offer which my client has instructed me to give, that Blood Builders complete the project within the stipulated time, that is September 2023, and we are willing to increase the total budget by 15 million piastras, and we are willing to give an instant payment of 55 million piastras so that the work could be commenced at the full momentum.
Okay, what does the other party have to say about this offer?
First of all, I would like to add that we did not intend to cause any harm purposefully, and all of these expenses that is incurring and the time taken is circumstantial. We have been providing our services from the past years and never faced any criticism of this sort. And it is totally the unforeseeable situation that led us here. Also, we are open to negotiating the terms, but not just in cost. We would require a few more days for the completion of the project, since we have to acquire Ceratanium, the material which is from Newcastle to Etienne. So we have to transport it from that place to the place of construction. So that is also incurring expenses, and it would also take some time.
So actually the other party want the extension of time.
Yes, we would like an extension of up to 12 months if it is possible, because we, as my client stated, she would not like to compromise on the quality of the building that she's building, as compromising it will affect her reputation as well. And as per the increase in the amount that we require, we are willing to go down up to 70 million, which is itself is compromising what we are in need of.
Okay, so just to put it to the other side, the offer from Blood Builders is that the Vandelay development provide them an extension of 12 months. And they also are willing to bring back their compensation amount from $75 million to 70 million. What the other side has to say on this?
First, I would like to ask a question. Is it okay with the mediators and the opposite party if we just, for now, we just negotiate about the extension time, and then
Yes,
we'll deal
sure.
about the money later?
Sure, you can proceed.
Okay. So the maximum amount of time, maximum amount of extension which my client could provide is of 4 months. That's the maximum amount of time which is possible for my client to provide you. So is it okay with the other party?
4 months of time for completion of such an extensive work would require additional charges. If the client, Ms. Veronica, is open for negotiating the prices might go high because of requiring high laborers and technicians. Of course, we need to incur so many expenses.
So can I conclude that you guys are willing to negotiate on the timeline if the compensation is raised, right? Yeah. So does the other party have anything to say on that? Are they willing to increase or raise the compensation so that both of you come on same ground?
Now, I would like to mention that when the contract was initially signed, they would have made provisions for arranging the machinery. So we know that the situation about that excavation project, we know that it is an uncertain thing that they couldn't have control. But for machinery, they should have made a provision from the beginning of the project. So we are now willing to extend the project for 5 months. And along with this, we want an explanation and a compensation of 20 million piastras for the delay in the project.
And also adding on to what my counsel just said, you also have to be understanding towards our constraints. I just stated in my grievances that, we have to answer both the customers as well as the government. And a government contract is, it impacts our goodwill as well. So that's why government contract is of essence, the time is of essence, and we cannot compromise on that. And the maximum time we could give, as my counsel stated, is of 5 months.
Can I ask you a question, Ms. Veronica? Okay, you have stated in your opening statement that it is because that you don't know what the underlying reasons for the extension is. It's because of that you couldn't convey to the government about the delay in the project. You said you would like to know about it and then tell the government about the delay.
Sorry, could you rephrase? I couldn't understand.
Well, in the beginning of your opening statement, you've stated that you would like to know what exactly the underlying reasons are, and that if you understand it, then you would be willing to convey that to the government.
No, I didn't state that I will be willing to state it to the government. I want you guys to tell us what are the underlying reasons for the project, how the project damaged, because out of nowhere we receive a letter which is stating that, okay, there are certain changes, unforeseen changes that have, we understand that due to COVID, an abandoned site will be deteriorated, but we want the specifics of that. And regarding the government, it's only for the time, because see, a project which is being completed under the aegis of government requires us to be punctual on time. The government is involved in here, so that's why it's of utmost importance to us as well as to you. That's why.
All right, but my client is one who never compromises on her quality, and because of that, the only product that we can use is this one which the government has levied taxes on. So to procure that, we would require extra money, which was not a foreseeable circumstance by us also. And not only that, it was because of the unavailability of the labor due to the health protocols that is established by the COVID-19 by your government as well as mine. And also it is hard to find reliable laborers to work because there is no necessary way of knowing when their health will be compromised due to these situation.
I completely understand that costs will be raised. That's why we are willing to negotiate on the cost as well. But right now, for this purpose, we are going to only negotiate on extension. Later on, we'll certainly negotiate on the budget price in the second or third agenda, whatever it is. Right now, extension of time is of our concern. And I would actually like to call for a caucus because of certain, things that I have to tell.
Sure. Session supervisor, would it be possible to put us in a breakout room so that we can facilitate the discussion? I think we want IMC-V-2022 and her council to be with us, and the other parties to be in the breakout room.
Okay. So we are creating a breakout room for council 222 and client 222. Am I right?
Yeah.
Wait a moment. Please do join the breakout room.
I think they are already out.
Okay, so before we begin with the caucus, I would again like to inform the parties that this has an additional layer of confidentiality attached to it. Nothing said here can be used outside of this session or in future litigations. So be absolutely transparent and open, and you can put forth any ideas that you want to. And we will not be conveying the same information to the other party until you expressly permit us to do the same.
Okay, so actually telling you why we enter into a contract with blood builders is obviously because they are efficient, and we know that their plans have been cost effective. They use the best technology. And the thing is, we are not facing any shortage of funds. We wish to negotiate only if they could complete the contract within the stipulated time or whatever is being negotiated here. The thing is, we do not, the thing is, before coming into this mediation, we all had to basically, we all had in our minds that we will go for arbitration, but we know that it is time consuming and expensive. That's why we do not want you to tell them that we are not going for it. Our side, Vanley Developments, will not be going for arbitration because it is time consuming and it will cost us sums. That's why. But we have to tell you that we cannot delay the project for a period of 15 months because already we are under pressure from the board for it to be completed. The thing is, our contract had a force majeure clause, for COVID disruption, but the delays, it should not account for the delays that are caused by their default. And the thing is, we do not want them to know that, some of our hiring contracts, the customers that we have, the contracts that we have entered into with certain customers of ours, that can be delayed by some months. However, we are willing to extend the time between like up to like 5, 6 or around like 7 months. But yeah, I mean, that's something that we wish to convey.
So you are ready to compensate, like you are ready to give about 7 months time to the other party to complete the work, right?
Yeah, only if, see, I do not want you to tell this to them, because they won't be, because see,
it's a confidential process and we won't be sharing unless and until you say to be shared.
Yeah.
So what the client wanted here to say is, I'll just sum up for the convenience of everyone. You have no shortage of fund at your end. You just want the timely completion of the project. You are willing to extend it, but only up to 7 months at max. You also have the information that some of the contracts with your customers can be delayed, but you don't want the same to be conveyed to the other party, right? So first of all, your basic instance is that you want a timely completion, but in case it can not be done, you are willing to not extend it to 15 months, but 7 months at max, right? Is that it?
Yes. And we also want damages for the delay, if till that extent, since we have already entered into contracts, if the project gets delayed, the damage caused till that date, we want that. We are willing to negotiate on that. We won't be asking for that much, but yeah, we are willing to negotiate on that.
Okay. Does the council have something else to add?
Yeah, just to add to what my client said, that we have funds, but we cannot give them as much they are currently asking for. The maximum we can go is around 55 million PSTRs. So we want an agreement around that figure only. So that's the max we can go.
All right. So can I put forth that to the other party that although you want the timely completion of the project, you are willing to negotiate on the timeline, but it will stay up to maximum 7 months, and you will be claiming damages for the months that you have given extension for, right? Is that correct?
Yes, that's correct.
Anything else? Okay, so I think we can have the other party here.
Wait a moment, we are adding the other party. The council will be joining in 28 seconds. Yes, she has joined.
Yeah. So I believe the other party is here. Just to give the other party a brief of what we discussed with the Vandelay development in the caucus, I'll put it forth to you guys. They basically, what they want is that they want a timely completion of the offer. They, for now, they want the timely completion. They are willing to go for an extension, but not for 15 months, at max 7 months. And if they go for an extension, they will be demanding for damages of the delay or the extended period. So this is what they told us and asked us to put forth to you guys. So do you have any take on this?
Well, Mediator, we would like to call for a caucus session to further discuss on it. Thank you.
Sure. Session supervisor, would you put IMC-V-2022 and her council in a breakout room?
Yes, we will. Wait a minute. Wait a moment. We are creating one. Client and counsel, can you just join the breakout room? Thank you.
Okay, I think they have joined. And at the very instance, I would like to inform you about the confidentiality clause in this session. Anything you tell us, the mediators, won't be shared with the other party unless and until you choose it to be conveyed. Right? Yeah. Further, the parties can go ahead.
First of all, I'd like to mention that the price we quoted was lower than what was ideal, and the time frame was purely optimistic, which was done by us in a due consideration for winning the bid. And as of now, for the damages that was caused to the site during the lockdown, we are also greatly embarrassed as it was a mistake from our part, and which also led us to incurring a lot more expenses, which was not adequate. Right as now, we are open to negotiation in shortening the period of completion from 15 months to 9 months at max. We cannot shorten the time more than 9 months. Even 9 months shortening is possible only perhaps if the money provided would be right.
Okay.
I would want you to please elaborate a bit on the last one. Money provided would be appropriate. Like, do you have any specific amount or any details?
The first amount we asked for was 75 million. Now we are negotiating at 50 million.
Okay. So do you want this to be conveyed in the joint session?
Yes.
Okay.
And also one more thing that the other team mentioned was that they were asking for damages if the period was being increased. And I would like to state that we were also asking for compensation because of the defamatory damage that was caused to my client. So if we can make out a deal wherein which the compensation that my client needs for the deals being followed out because of her reputation, and for the damages that the other party has also been caused. So so we are hoping that a deal can be brokered out according to both the compensation, the compensation that we are supposed to pay them, and also the compensation that they are supposed to pay us with regards to the damages that my client was caused.
Okay, so this is also to be conveyed in the joint session, right?
Yes, and no other matter that was discussed here, we don't want to be conveyed. That is the reputation related matters. We don't want it because it might harm my client's reputation.
Sure. Session supervisor, would you put in the other teams also?
Just a second, like before you put in the other team, I'll first like to confirm what is the offer of the team. First of all, you're willing to negotiate on the extension period for 9 months only if the compensation provided to you is right, which is 50 million. And you are willing to find a common ground on the compensation for the reputation of your client and the damage that they are claiming for regarding the extension period. I think that's about it, right? Yeah, I think we can have the other team now.
Wait a moment, we are adding the other team. They would join the meeting in 60 seconds. Yeah, they joined.
I think he has joined. Like, yeah, we have discussed with blood builders and they wanted to be conveyed certain things to you, and they actually required 15 months for the completion of the work, and they're ready to compensate for 9 months, and they are in a way that they can they'll try to complete the work within 9 months. And at the beginning, they have asked for restarting the work 75 millions. And now they are ready to compensate that and bring it down to $50 million. And for the compensation that you have asked, in the previous time for the delay cost, you asked that if at all any delay is being caused, you are likely to get some compensation. So what the blood builder and their counsel says is that actually blood builder has suffered some defamation and all, so they're claiming for that damages, and you are also claiming for the other damages that's causing for a delay. So they are trying to compensate both the damages together, and there will be no compensation.
Just to add on to what my co-mediator said, I want to add an if clause here that the parties mentioned us to add on to. They're only willing to negotiate on the time period till 9 months if the money provided to them is appropriate, that is 50 million, right? So if there is a if clause there, if you guys are willing to settle on the 50 million amount, then they're willing to go for the time period of 9 months. And then they also said that compensation for the reputation can be found on a common ground for the damages of delay that you are asking for. So the other party has any inputs, they can go ahead.
So regarding the possible defamation, event that happened, I agree that, in the capacity of an MD for the company, I gave a speech at the International Association for Builders, which certainly, created their bad image in the business world. However, what I said was not, wrong totally. It was true on my part, because we as a company, we felt that they were giving us vague assurances. They were not sure when the work is to start, when the work is to complete, how much they want, for what they want. The specifics were not given to us. That's why I made a statement that they are amateurish, which simply means that they do not have this professional skill that is needed for the business industry. However, still, now that we are continuing with the project, I know that there are concerns related to it. I will be, I will be willing to be, I will be flexible to whatever suits them. If they want me to give a clarification, I'll certainly give that.
Is the other party willing to accept the offer of giving a clarification, like the clarification from Vandelay Developments? Is the other party fine with it?
The clarification means no compensation. Can you just make it clear, please?
Clarification in the media, that is, what I said was from this perspective, but it was not totally true. But yeah, I mean, the circumstances were the circumstances were such that I had to make the statement. That was a clarification.
Does the client mean that it's a kind of public apology?
Yeah, sort of, but yeah, clarification means clarification, but yeah, a public apology will do good.
Just to put forward more clearly what my client said is that since what she said was not false, so it doesn't amount to defamation, but she is still willing to give a public clarification that from what point of view, or because of what series of event she said that she shared that term, and by that term what did she mean, what did she mean, because what she said was completely true, and on her account there was no defamation at all. This is what my client is of the opinion of.
So I believe the party is saying that they would like to clarify that whatever statement that they made it in the light that they believed it to be true, and it was kind of misinterpreted in the press, and they are willing to clarify the same misinterpretation if the other party is willing to accept this.
Yes, that's totally right.
Is the other party willing to accept this?
Just a clarification would not be enough, because of the statement which Veronica made, we have lost many of our business deals. So we're not agreeing to the clarification.
I totally understand, but the thing is, you have not filed any case or a suit in the court, right? Then for what damages? You are asking for damages, right? If I'm not wrong, you're asking for damages for what? For the statement I made.
Well, to clarify on that, we did not file a defamatory case because we thought we would clarify that in this mediation, and we didn't want to drag you into a whole arbitration or litigation. It's because of that we did not file a defamatory case against you.
No, I understand
just to
that.
Clarify,
okay.
Just to clarify what my client said is, though she may have selected some wrong words, but what she meant is that on her account, there was no defamation at all, because what she shared was true. And it was the respective, it was everyone's point of view, that from what point of view that they understood the word amateurism. Because according to her, she explained the factual matrix. I would not divulge into that again. But what she said was true. So there accounts no defamation on our part. So there's no need for my client. She's of the opinion that there's no need for her to go for a public apology or compensation. So what she all can offer is a public clarification.
Well, as my client, as my client has stated, what you said right now is not exactly the truth. My client has never ever compromised on her quality and calling her immature in the presence of an international committee and international committee. I'm sure that Veronica knew what all consequences it would have caused to my client by calling her immature in front of an international conference. And no matter what you said, it is not true, and she knew what she was saying. Calling her contractor immature, she knew that will cause damages to my client also.
I believe I'll have to interrupt the parties here. We have run out of that time. I think we can have more sessions and we can discuss this issue further. I think what the parties have agreed to, they are willing to settle this dispute amicably. Also regarding the public statement, I think one side meant that their term had been misinterpreted by the media and portrayed the same, and they had no intention to defame the other party, while the other party believed that they have been defamed. So I think we have made a great progress in today's session, and by organizing other sessions, we can surely resolve this. I would like to thank all of you to coming to mediation once again.
Thank you so much, co-mediator. And of course, I agree with the co-mediator, whatever she did summarize. And I also like to thank the parties, especially for choosing mediation and being ever so cooperative. And I think in further session, we can come to a conclusion in this problem. And I get that you all have had a path and you all choose the path to put on time. Yeah, thank you so much.
Yes, we have come to an end. All of feel free and relaxed. The same smile in the start is there. Yes, I can see all the smile. So judges, now we are officially done with the final. You may give the concluding remarks to the participants. Who will go first?
Shall I go first? Is that okay with everybody? Well, just thank you so much, everyone, for participating in this final. I'm not surprised that the two teams are finalists because I thought you did incredibly well. And the dispute is, I guess, it's quite technical, it's quite complicated, lots of different figures and time, deadlines and times changing. So it's quite hard to keep track of all those things. And I guess I'm a little bit sad that we didn't have more time, to be honest, because I think you began to start to make substantive progress on different issues. And I guess another half an hour might have been good in this kind of scenario. Actually, you would have perhaps got to some kind of resolution. But I saw a lot of really good activity actually here in the mediation. And a big part of it is just getting out information, taking more detail, so the parties have a chance to understand each other a bit better about why something's happened, why the delay, why the price is rising. On the other side, why a company cannot agree to an extension because of their own pressures. And that's part of the beauty of mediation, I think. And I saw a lot of that come out here today. Just a few more specific comments. I thought that both mediators did really well. I think that co-mediation is challenging, and particularly co-mediating with someone that you don't know. And I guess you had maybe half an hour to discuss in advance how you would approach it. Now, of course, in the real world, we do co-mediation, but often with people we know extremely well. And you have that kind of natural rapport and relationship. And I guess today, you maybe didn't work it as a team as well as you might have ideally, but it's not surprising given the situation you're in, because you are being judged. And of course, you want to exhibit your skills, and there's a limited time. So there's a little bit of, I guess, an unevenness between you occasionally. And I guess, I think that the way to try to resolve that perhaps is by sort of developing a technique in advance. And it's quite useful if someone's speaking to just pass over to the co-mediator at the end of it and say, have you anything to add, rather than the co-mediator coming in. And I guess I noticed that really quickly when the opening statements were being given, and the Mediator IMC-V-2022, you summarized what was being said. And you rightly said, have I got that right? And the client said, well, actually, no, I want to add something else here that you've missed. But the Mediator IMC-V-228 came in there, and even though the client had started to, say what was missing, and you said, I think I can do this. And I guess you didn't need to do that because, he was doing it, and the council actually was doing it at that point. That's just one thing, but I guess that, you know, there are little aspects of that occasionally, but good. In terms of both teams, I thought both teams presented really good opening statements. I think the teams worked well together as partners in the sense that you were making use of the clients were making use of the council. You weren't just repeating each other. I thought that worked pretty well. I think that I guess one thing I would say to IMC-V-2022 in your opening statement, it came across as a little bit adversarial, I guess. You know, the client you went into, you know, I think talking about your case and what you were looking for, it felt to me you could have been a little bit more collaborative in terms of at the outset giving a few sort of, you know, thank you for being here and, you know, trying to set the tone a little bit better. And I think that got better as you went on. Absolutely. But yeah, it was really good, I think. And I thought there was some really good questioning. So counsel for IMC-V-2022, you did seem to me to be listening. So you were picking up on things that were happening in the room and you were asking for clarity around that. And I think it's a key thing in the mediation. I know I'm doing lots of talking now, but, you know, I think Al had said yesterday, you've got one of these and you've got two of these. You've got to listen and respond to what's going on. And there was some great examples of that. So I'll stop talking now. Well done, everyone. I thought that the level was very, very good overall. And I think you should all be very proud. So thank you so much. And I'll let the other judges now speak. So thank you.
Thank you, Bryan, for the word. Now who is going for the next? We have Justice Devan Ramachandran and Dr. Sherif.
All right, I'll step in, no problem. I thought I let Dr. Sherif do the honors first because he was not here last time. So Sherif, if you want, you can on. I can wait.
After you, Justice, after you.
All right, okay. Dr. Clark has summarized most of the session. But for me, it was a slight anticlimax. I would have expected a resolution. I believe that you could have gone in for a resolution. It was possible. The session was too civil than it would have been had real disputes been tried to be resolved through a mediation like this. You were all extremely, extremely civil and diplomatic. You could have been slightly more politically improper. There was nothing wrong in doing that. You could have pushed yourself slightly more harder. Eventually, what we were seeing is that it was a play of egos. You wanted, your reputation to be, I mean, the Bluth or whatever. They wanted their reputation to be put on track. The other side was trying to tell you that, look, I did not intend to tarnish you, to deracinate your reputation. It was only a frustration that came out. So the mediators could have pushed in, perhaps because we were seeing that eventually the difference was very little, 9 months or 8 months or something, and more or less the same amount of money, 60 million or whatever. I don't know. I don't remember, 50 or 60 million. So we had almost a meeting point there. All that we required to do was to flare the egos and then get it done. That could have been done easily. I would have loved to give you a tie today because I don't think any team was better than the other. You are both brilliant and good. But then I'm expected to, not to use a tie. I was told very specifically because the way I think the lawyers know me here, I have a tendency not to find either in favor or against a party and the more relief. I can't do that when I'm sitting in a mediation. So I will be marking you, but I'll be using it. So just for your information, whoever I find better, it's not because you are better today. It's because the nuances that we are now watching today would possibly give you an edge, nothing more. The mark, as far as I'm concerned, would be a difference of 1 or 2 marks at the best. All of you did very well. The mediators could have gone slightly more proactive. That's all that I was, both of you. Not that, either of you were less or more. Both of you could have pushed it a little bit more. Possibly we could have had a mediation without another session. I think, what was the session, 45 minutes? What was it given, session observer? Was it 45 minutes?
50 minutes.
50 minutes, so it's more or less there. I think we could have broken the impasse today. So that's the only thing I said. It was possible. But good luck to all of you and very well done. Congratulations.
Thank you, Justice Devan Ramachandran, sir, for your words. That was really amazing. Now we have Dr. Sherif. So,
Thank you very much. Can you all hear me well? Good. I'm very proud of all of you, and congratulations for reaching to the finals. You've demonstrated good mediation advocacy skills, good mediation skills, and you should all be proud. I would love to give you a little bit of tips, but before saying this, it is not fair to deal with such complicated case in just less than an hour. Ideally, this case would take a day or two in mediation to reach to a settlement or a informed decision. So I understand the amount of pressure that you've been dealing with, and I know that you were trying to do all of the skills that you know of and all of the process with the phases in a very short time, and I feel you. I feel all of the struggle that you were going through. So please, the small comments and tips that I'm telling you, it's not. It would be very hard to do it in very short time, but just in real life, when you are ready in practice, maybe this can come handy. The first thing was the mediator's statement. It worked like magic when the mediator introduced themselves in a professional level and also a little bit of personal level before asking the parties to introduce themselves. If the parties picked you, so they sure that you are competent, but stress on your competencies. Tell them about your experience. Tell them about your education. Tell them about your strength in your introduction, and also mention a little bit of your personal. If you are a mother or if you're a father of daughter, mention this. If you have hobbies and you found it appropriate, why not mention it? This really toned down the stress and also prove that it's an informal process. And usually the parties, when you ask them to introduce themselves, they follow your lead. They will tell something about their profession, and also they will tell something personal. Try to find commonality. One of the cases when I said this, we found out that our kids go to the same school. And this really toned down all of the aggression and the tension. And we started to talk about the children in the school in the beginning of the mediation, and you can feel that it has really built rapport with all of the parties involved. So this is one point. The second point was the exploration phase. I've noted, which is, I understand it was stressful, but you did not spend enough time with the exploration phase. You really jumped in for having an offer and responding to the offer. So you jumped to the negotiation phase without learning the real interest for both parties. It seemed that there are different interests hidden. There is an interest for time, for this money. There is an interest for self-image or the reputation. And I'm sure there was other several interests. Before pushing the parties or going to extracting out of them an offer and counter offer, try first to understand better what would make them happy, what would they try to achieve, and then help them to construct an offer and the counter offer. You have used the question and the summary technique, which is good to understand better. And a small tip that really works, if you have a flip chart, and when you are discussing with them different issues, if you found issues that they have in common, write it down in the flip chart. And the topics that they have disagreement, also write it down. This would give an image for the parties to see, oh, so this is all about, this is what it's all about. And once they actually manage to sort one of the topic, scratch it from the disagreement and put it with the agreement. It gives them sense of achievement. It gives them sense of moving forward. So this is an extra tool that you might find, use it with the exploration phase. With the negotiation phase, another small tip is when you receive an offer and when you give the counter offer, try to encourage the parties to include logic behind each number, behind each figure or an offer. this would give them a sense of, why would I ask for this? Why would the other party agree on this? So give them the chance as, I understand the offer. Would you please give me some ammunition, give me something to help me to convince the other party? What would be the logic? Here you are really helping the parties to develop a good sense of judgment of their own position. And also ask the parties, before responding to this offer, respond to the logic they are bringing with. And if you are giving a counter offer, give them a counter logic. Also, this would help a lot. I hope these small tips would help you later on in the future. Once again, I'm really happy and fortunate to see all of you and your passion and enthusiasm. I really enjoyed it. It was very refreshing. And I wish you all the very best. And to me, you are all winners and you all should be proud. Thank you, Professor Bryan and Justice Devan, for this great opportunity. And I'm happy to be in collaboration with both of you.
That was really amazing. As I said earlier, we are fortunate to have such a wonderful panel of judges. Just a reminder, you can update the score sheet, which was sent prior to the session, made it back. Then what next? We are come to the end of this great 2 days. So let me conclude by expressing my gratitude to all of the participants for your active participation and efforts. We are all thankful of the invited judges, organizers, and above all, the Almighty who made this possible. I request participants may leave the meeting. You can see the valedictory function through the YouTube. The link will be provided by the team manager. And the judges, we would be more happy if the judges could stay back for the valedictory function, which will begin at 5:30 p.m. IST. You can take a break also. All good, right?
Is the same meeting, are we continuing in the same platform?
Yes,
same
sir.
meeting?
Yes, sir. Thank you so much, Afro.
Thank you. Thank you again to all teams. You did a wonderful job. Lovely to meet all of you and best of luck for the future.
Sir, if I may speak, it was an honor performing in front of all of you. Thank you for your insightful feedback. Thank you.
Yeah, the feedback will surely help us in future mediation sessions. So we are really grateful for that. Thank you so much.
Thank you, judges. We will certainly consider all the feedback that you provided us with. Thank you.
Judges, you can take a break. It is okay.
Just to clarify, so we're meeting again after 30 minutes?
It's like just in 8 minutes. Within 8 minutes, we will start our valedictory function. For that time, you can take a break.
Okay.
Now, how are you going to announce the winners? I mean, how are they going to know when they are not in the meeting? They see it through the YouTube platform, is it?
We are actually live streaming the whole process.
Okay.
So we all have a link for it. So they also get the same link.
But they are not here, is it? They are all far away. Are they very far away from other parts of the world, other parts of the country? Okay. That's nice.
International, yeah.
That's right. That's right.
We also have international participants. All around the world, we have.
All right. Oh, very nice. All right. See you in about 8 to 7 minutes.
Greetings, one and all. Welcome to the valedictory function of the second International Mediation Competition, Virtual 2022, organized by His Highness the Maharaja's Government Law College, Ernakulam, in association with Lex Erudites.
Today, to grace the occasion, we have with us Honorable Justice Devan Ramachandran, High Court of Kerala, Honorable Dr. Sherif Elnegahy, Chief Justice, Cairo Economic Court and Mediator, Global Mediation Panel at UN, Professor Dr. Bryan, Professor of Law and Civil Justice, and the Academic Head at Newcastle University, United Kingdom. He is also the patron of this competition and an advisor to Lex Erudites.
We also have Dr. Bindu M. Nambiar, Principal of His Highness the Maharaja's Government Law College, Ernakulam, Dr. Gifty Umman, Associate Professor of Government Law College, Ernakulam, and Advocate Akhil George Philip, Editor-in-Chief, Lex Erudites. On that note, I am Atmaja Menon from Lex Erudites, and
I am Karthik Menon from Lex Erudites,
and we'll be the host for the function today. Now, I invite Dr. Gifty Umman, Associate Professor of Government Law College, Ernakulam, to deliver the welcome speech.
A very good evening to one and all. It's indeed a prestigious occasion for our college, Government Law College, Ernakulam, to be in association with Lex Erudites to bring in this program, the International Mediation Competition. Of course, we know the importance of mediation, and training of students is a very important feature in it. And that is the reason why we've undertaken this venture. And we're very proud to have part of the alumni also involved in it. Now, coming to my duty of welcoming each of you, let me welcome our principal, Dr. Bindu Nambiar, who has been the pillar of encouragement for us, for the programs of this college and its association with various institutes. Thank you, ma'am. I welcome you, ma'am, to this occasion.
Thank you, Gifty.
Thank you, ma'am. Next, we have our alumni, Honorable Justice Devan Ramachandran, Justice, High Court of Kerala. Sir is a very eminent personality, and he's a part and parcel of a college, and it's proud to say that he's an alumni of this college. And you will find that he is a very proactive person, bringing in so much of progressive thoughts, human rights jurisprudence, and like he is a man of the day. If you talk about jurisprudence. And he has brought in so many decisions which normally traditional judges would fear to venture into. He has brought in judgments wherein he has bring in, strictures against the police, strictures against the labor code, and he has been in favor of the citizens. So it's a real proud moment to welcome you, sir, to this occasion. Welcome, sir. I hope he's there.
Yeah, I thank you. Thank you so much. Thank you.
Okay, sir. Okay, sir.
Kind.
Yes, sir. Yes, sir. Next, we have Honorable Dr. Sherif Elnegahy, Chief Judge, Cairo Economic Court, Egypt, and Mediator of the Global Mediation Panel of the Office of Ombudsman for UN Funds and Programs at United Nations. Well, as the name suggests, he's a person known in the field of mediation. And what needs to be taken note of is he's working among people and training them, especially in the Middle East. He's a person known in Saudi Arabia, in Egypt, where he's training people and advocates and even judges to bring in the importance of mediation. And he's even co-authored a book in Arabic, for that matter. I welcome you, sir, to this occasion. I hope, sir.
Thank you very much. Yes, thank you very much. It's an honor to participate in this. Such a pleasure. And I was very proud to see all of the students and their participation. Thank you very much.
Welcome, sir. Next, we have Professor Dr. Bryan Clark, Professor of Law and Civil Justice and the Deputy Head of Academic Affairs at the Newcastle Law School, United Kingdom. And he is the pillar stone behind the Lex Erudites, and he's in the Board of Advisors. And he has lots and lots of articles to his name, especially in the area of mediation. And it's a privilege, sir, to have you here. Welcome, sir. Welcome, Bryan, sir.
Thank you so much. It's my pleasure to be here. It was really fantastic to be judging again with Justice Devan, sir, and also Sherif as well, who I've known for many, many years. So that was a fantastic occasion. So thank you so much.
Welcome, sir. And of course, we have our advocate Akhil George, who's editor-in-chief of Lex Erudites, alumni, and my student of this college. I also welcome to the occasion Karthik Menon, student editor and Lex Erudites, and all who are participating in this program and of course awaiting for your results. I welcome you all, one and all, to this occasion. Thank you.
Thank you, ma'am.
Now, I invite Dr. Bindu Nambiar, Principal, Government Law College, Ernakulam, to deliver the presidential lectures. Ma'am, please.
Thank you. Am I audible?
Yes, ma'am, you're audible.
Okay. Honorable Justice Devan Ramachandran, Dr. Sherif Elnegahy, Professor Dr. Bryan Clark, Dr. Gifty Uman, Advocate Akhil George, participants, colleagues, friends, and my dear students, a very warm good evening to one and all. Today, we have come to the close of a two-day second international mediation competition. It has been an exciting 3 days. I would like to congratulate all the teams who have participated in the competition, and special congratulations to the teams who have made their way to the final round. Now, all of you have gained a first-hand experience of how an actual mediation works, and that a mediator does not impose a solution, but creates a conducive environment in which the disputing parties can resolve their disputes. Recognizing the role of a mediator being very crucial and is of very importance, as he or she has to remove obstacles, identify issues, and explore options while facilitating mutually accepted agreements. His Highness Maharaja's Government Law College have always been in the forefront of promoting alternate dispute resolution mechanism. From this competition, our students got the golden opportunity to observe the mediation skills which were shown by our participating teams, and from the wealth of knowledge of our distinguished judges. While we are eagerly waiting for the results, I may take this opportunity to congratulate and thank our faculty coordinator, Professor Srimain Abubakar, student coordinators, all volunteers and members of Lex Erudite for successfully organizing this international mediation competition. It has been a pleasure to work with these enthusiastic youngsters who all had worked very hard to realize our dream of organizing this international mediation competition. All teams have performed very well. Congratulations. Only one team can win a competition. Congratulations in advance to the winning team. I'm sure our participants have gained invaluable experience competing with each other and got direction from the expert panel of judges and had a taste of how a real mediation would be like. This will surely help all of you in your future endeavor. All the very best to each one of you to a bright future. Thank you very much. Jai Hind.
Thank you, ma'am. Now, I humbly invite Honorable Justice Devan Ramachandran, sir, Judge, High Court of Kerala, to deliver the valedictory address. As we all know, Justice Devan Ramachandran, sir, has actively involved in matters of social interest and public courts. It is an honor for me to once again welcome the People's Judge and one of the most vibrant judges of the High Court of Kerala, Honorable Justice Devan Ramachandran, sir, to deliver the valedictory address. Over to you, sir.
Thank you, Atmaja, for being so very kind. I don't deserve it. This is the second year I've been witnessing this wonderful phenomenon called mediation. As a lawyer, I must confess that I never was part of a mediation process. Though my associates would have done that on my behalf, but I was never physically part of any such process. I was a litigation lawyer, and I was a litigation lawyer from the beginning to the end. As a judge, I don't get to see the process either, because the mediation generally takes place at the mediation center or the settlement center. But every time you think about a settlement, the first, the quote that comes to your mind running is Abraham Lincoln's famous, "A good settlement is better than a good lawsuit." Now that has transformed itself. It has actually transmuted itself to a bad compromise is better than a good lawsuit. Because we know the pitfalls that litigation can take you all over the world. It's not in India alone. Though in India, the concepts of docket explosion, the problems of time is slightly more aggravated. For all the students who are part of the process today, and everybody is hearing this, there are certain things that are that make mediation much more attractive these days. We all know the concepts of privacy. We know the concepts of confidentiality. Now, while litigation generally, unless it is an in-camera proceedings, which rarely is, there is a complete breach of confidentiality as far as the parties are concerned. All your disputes come out in the open. Everything is handled threadbare these days in open courts or even in the online hybrid systems, all thanks to the COVID-19 transformation. So everything that, for example, the problem that we had today, there was an issue as to one of the parties bad-mouthing the other side. Now, if that is taken to a lawsuit or a litigation, all those issues will come out in the open. So there was a complete breach of confidentiality and privacy issues, and very important these days. Time, of course, everybody talks about time. It says that you can save time. Litigations take much more time. Economic reasons, I don't have to tell you. They say that it's much more cheaper. I'm not sure of that, because sometimes good lawsuits possibly may not be that expensive, though time frames, yes. But the most important is that the alternatives, the availability of alternatives to a party. They are the master of the entire process. Mediation happens when you are ready for it. Nothing goes beyond your control. It's only if you agree to something. If you completely agree and concur with what is happening, then the process goes on. So there's a lot of power with the parties going for a settlement, and they have the alternatives. Availability of alternatives, like it's impossible in a litigation or an adversarial litigation. I always say every litigation there is a problem. There is an after effect of bitterness. When a court delivers a judgment, I don't think the losing party would accept it because they were wrong. Because the problem with litigation, generally, as we have seen all over the world, is that both the sides think that they are right. And they're justified in thinking so. I'm not saying one is wrong and the other is right. But in the adjudicating process, especially when we hear matters and take a call, it is inevitable that we have to take a call on one side, and we may have to find the other to be right or not so very right. Now, that leaves a trail of bitterness. It leads to a lot of litigations, again, appeals after appeals, reviews, rejoinders, and all kinds of things that happens. But then, if you solve that problem through a settlement, in the presence of very competent mediators like Mr. Sherif, who's here today, now that takes away the bitterness out of the entire equation. The parties have no bitterness left because they understand that they have got the best within the opportunities that they have. And then it is less ceremonial, especially litigations all over the world. I don't know about some of the other countries, but where we follow the Commonwealth systems, we follow a lot of ceremonies, a lot of formalities. Now that is taken away. It's much more informal. You are in the presence of the mediator, wherever you want to be. It's your choice of place, it's your choice of time, it's your choice of occasion, location, everything. So there you get a lot of flexibility. And finally, you end up feeling that, look, I was a master of the process. Both sides get that feeling. They get a lot of fulfillment if it comes through. In fact, today's session that we are watching, the three of us were watching, did not have a conclusion. You would have been happy if there was a conclusion. It is possible. But if you find a conclusion through a settlement, then it brings in all these benefits. it actually brings down the number of litigations that way, because then an appeal and a second appeal, and possibly a third appeal, all of them are just taken away. So that way, docket explosion gets controlled, and there is a lot of difference in the manner it is. And there is a complete cessation. You feel fulfilled that you've done this. Now, I said that I was not part of the mediation process, but I must say that when I was especially in the civil litigation jurisdiction, and I was hearing the first appeals and all that, I was trying to push all those litigations which were at least 5 years old into settlements, into mediations. And I must say with great amount of pride that at least 20-30% of the cases came back settled, which in India is a big thing. It's a very big thing. We're talking about so much of cases pending. To say 20 or 30, if not more, came back with a positive result during the mediation is a wonderful thing. So it definitely is a career option for the lawyers, and it is a great life option for the litigants. Now, after all, we are all here for the litigants. There's no choice for us but to understand the mind of the litigants, to understand what they want. And I always say in court, no litigant is concerned about what happens in court. They don't care if their lawyers have had cutting-edge arguments and the judges have been floored or the judges have not been impressed or anything. They want their things done. A litigant gets justification when he gets a result. He doesn't care what happens in the court. He doesn't care whether we have led the law, we have laid down the law, we have postulated the law. He doesn't care. So except that in the statistics, his name comes out as Mr. So-and-so was a so-and-so in the precedents that we talk about. He doesn't care. For him, all that he looks at is whether he's won the case or otherwise. If he loses it, it goes in an appeal. So that is where this is very important. I've been always a votary of settlement. My opening remarks perhaps would have given you the wrong impression that I was against it. I am not. I'm in complete favor. But all that I said was I'm trained as a litigation lawyer. I lacked, or I do not know. I've never tried. But then looking at what I do in courts these days, I'm not a bad mediator. This is exactly what I do in courts also. I try and push people to a common ground if possible. And if I can't do that, I push them into mediation. If I can't do that either, then I have no other option but to deliver judgment. So mediation is definitely is the way to be in future. With the kind of litigation numbers that are coming in, I have no doubt that mediation is the way future. Arbitrations will only take the next 10. It is always mediations, and I believe that the students, in being trained to do this, it's a remarkable opportunity that is being created. We never had this. When we were students about 35 years ago, we knew either litigation or we went into a job, nothing else. It's either a litigation or a job. We never have these kind of permutations of the options that you get these days. So congratulations, everybody. As I said, I talked to the participants before the session. I told them, for me, it was a tie, but I was asked never to show a tie. And therefore, if I've marked any team better, it would have been only by a mark or a fraction of a mark, because I believe that all of them did exceptionally well. Whoever loses today, you have not lost. You are still the winner. All right. All the very best and congratulations to all of you.
Thank you so much for your kind words, sir. Law students really look up to you and they prove the inspiration to all of this. And one thing about internships is that when we enter the High Court of Kerala, it's almost an inevitable thing to enter the courtroom and try. So I want to take this opportunity to sincerely thank you for being a part of this conference, and we look forward to having you. Thank you.
Now, I invite Honorable Dr. Sherif Elnegahy, Chief Judge, Cairo Economic Court, Egypt, and Mediation Panel of the Office of the Ombudsman of UN Funds and Programs at the UN to deliver the special address. Over to you, sir.
I know that the students are eager to know the results, so I will be brief. It's just refreshing and a pleasure to see that academia, lawyers, judges are coming together in this wonderful competition to promote mediation worldwide. I believe mediation is simply a common sense for the litigants and can bring lots of profit and a new venture for lawyers as well. It's just impressive to see young law students from around the world competing and grasping the benefits of mediation, I believe this paves the way for a wonderful future for mediation worldwide. And it's a pleasure to be part of this competition, and thank you very much.
Thank you so much, sir, for your enlightening words and for gracing this occasion with your esteemed presence.
Next, I humbly invite Professor Dr. Bryan Clark, Professor of Law and Civil Justice, and the Deputy Academic Head at Newcastle University, United Kingdom, to deliver the felicitation address. Sir, please.
Well, thank you very much for that introduction. It's been wonderful to hear all the speakers today. And I think that these kind of events are incredibly important, I think, because what we're seeing across the globe is a development of mediation in many jurisdictions across all kinds of dispute areas, where it's really expanding and becoming a much more common part of legal practice. Now, of course, as Justice Devan was reminding us, settlement has been around for a long time. And certainly in England, my own jurisdiction, or my adopted jurisdiction, I'm actually Scottish, as you can probably tell. We're very proud of making that distinction, but I have worked in England for some time now. And settlement is really the major outcome of all litigation in England and has been for many years. But often that settlement has been, I guess, inefficient in the sense that it's taken a long time and parties have spent a great deal of money prior to getting to a very late settlement when court litigation is running parallel to that. And what mediation does, I think, is two things. It allows for more efficient resolution in the sense of brokering an earlier settlement to ongoing litigation. But it also, I think, increases the quality of that settlement as well, because of the role of the mediator within that. And the fact that parties are brought together, the barriers are broken down, they communicate more effectively, the mediator reality test puts pressure on parties. And what we end up having is a better quality of settlement, which can be creative as well, and not just deal with the matter at hand, but also think about how we might actually enhance the parties' ongoing relationship. Think about things which may allow them to proceed in a better way in the future together in terms of their business relationship. And that's absolutely key, I think, to the process. And as has been said, this is the second edition of this event. I really much enjoyed being involved in the event last year, getting it set up. It was a lot of work. There are obviously technical issues and drafting of problems and getting judges and recruiting teams. A huge amount of work goes on behind the scenes. Just to thank both the college and also Lex Erudites and all their teams for putting this event together. It's a huge undertaking and they've done a fantastic job again today. I think this particular event this year has been absolutely excellent. I've seen some really good teams. And I think, again, the two finalists were both really good. And as was said before, it was a very, very tight decision for me as well. I think actually counting up, I had 1 mark ultimately between the teams. So it's one of the closest finals I've ever said. Both sides had strengths and some aspects to work upon perhaps, but overall the standard was very high. And I know you'll be waiting to hear the decision very quickly, but as has been said, everyone was a winner today, I think, and both teams did incredibly well. So that's probably enough for me. You'll see that I'm wearing my kurta that I was gifted by the college and by Lex Erudites last year. I believe it's a khadi, a hand-woven khadi kurta. It's very comfortable, it fits very well. So yeah, I've been wearing it in the nice weather we're having in Scotland right now, which is very, very rare actually. It's usually raining or snowing or something like that. So it's very fitting at the moment. So thank you very much for the gifts that you gave me last year. But the gift is really just being involved in this competition, working with all these wonderful people, bringing people from different cultures, different backgrounds together. As Sherif said, academia, the judiciary, lawyers, students. It's a fantastic project and I hope it continues for many years. So thank you so much. It's been a real pleasure and honor again for me to be involved in this competition. And yeah, good luck to both teams now, as the decision I think will be imminent. Thank you so much.
Thank you so much, sir. Professor Dr. Bryan Clark is also the patron of the second International Mediation Competition 2022. He is also an advisor at Lex Erudites. Thank you so much for guiding us throughout this competition, sir.
Now, I invite Honorable Justice Devan Ramachandran, sir, to declare the results of the final round of the second international mediation competition jointly organized by Government Law College Ernakulam and Lex Erudites. Over to you, sir.
Oh, I'm supposed to do that. Okay. I'll tell you who the best mediator is first. The best mediator is Haley Doyle. I believe she's already online. She's from the Hillary Rodham Clinton School of Law, Swansea University. You're online, Ms. Doyle? Oh, yes. Yeah. Congratulations to you. You have been adjudged the best mediator.
Thank you.
The winner, the team winner is the, not bad, Cooperative Law College, Thodupuzha. Arati Ajay, who is Arati out of this? Arati, you are the counsel. All right. Dina Matthew or Dena Matthew. Why is it Dina Matthew?
Sir, it's Dena Matthew.
It's Dena Matthew. Where is Dena Matthew?
Sir, I'm here. I cannot see.
Oh, okay. All right. And Aisha Basila Ashraf.
Yes, sir.
Yeah, you are the client. You remember. Now, only for the purpose of formality, the runners-up is the Rajiv Gandhi National University of Law, Punjab. Ananya Sahu, Rachit Bijawat, and Subhi Vyas. Congratulations and all the best to all of you. Like I said again, I'm telling you again and again, I'm sure the Cooperative Law College must have won by a margin of about maybe a mark or 2 or 3 with all the 3 of us. We were all very, very close. So all the very best, or you're all winners. There have been no runners up today. It's all winners, really.
Thank you so much, sir.
Congratulations to all the teams. Congratulations, Cooperative Law College.
Thank you, ma'am.
Thank you, ma'am.
Congrats.
Thank you, sir. Congratulations to the winning team and to the best mediator, and all the best for your future endeavors. We were happy to have you on board.
On that note, I request Mr. Akhil George, Student Editor-in-Chief, Editor-in-Chief, Lex Erudites to propose the vote of thanks. Sir, could you please move on?
Thank you so much, Karthik. I would like to start by quoting John F. Kennedy. We must find time to stop and thank the people who make a difference in our life. In today's context, it is not life, it was a dream. The second edition dream of Lex Erudites have become a reality. And I think that there is no duty is more urgent than thanksgiving to all dignitaries and individuals who have supported in our journey throughout last year and this year. Without all these people, this competition would not have been possible. I venture into my official duty. Before that, I would also like to share the experience of being with Lex Erudites. I'm happy today, I'm privileged to be a part of Lex Erudites, representing them for the vote of thanks. And me and Advocate Gajendra Singh, who are also alumni of His Highness Maharaj Government Law College, we are happy that we could actually bridge Lex Erudites with the Government Law College Ernakulam, 2 entities who are traveling in the same dimension of excellence. And we are happy that we could be a reason for that. We have done nothing more than that, because all these things are done by the students who are talented students from different colleges who have come to a collective cause under the head of Lex Erudites, and also the talented students from my own college, Government Law College. So this idea of conducting mediation competition started from a very casual exchange of idea between the founders of Lex Erudites. So they came up with the idea during the COVID scenario. So me and Gajendra thought, I think this is something which should be promoted. To be honest, from my law college days, we didn't have any idea about any other competition other than moot court competitions. But the scenario exponentially changed, where when I started practicing, I found that there's much more scope for the ADR methods when it comes to high-stake matters: arbitration, mediation, and negotiation. However, in colleges, we mistakenly or inadvertently omit to emphasize the need to cultivate the mediating and ADR cultures. We just learned the subject in our 9th semester, nothing more than that. So we thought that the idea would give an advantage or an opportunity for students all over the world to inculcate the mediating skills and tools. And if we do it internationally, they could also reach the yardsticks in an international global manner, because these days international transactions are much more easier than before. So we found it very attractive, and then we approached my former teacher, Dr. Bindu Nambiar ma'am. It was through Girichangar sir who supported us with this idea, with our presentation. And then and before, Bindu Nambiar ma'am is always very pleasant, very pleasing, very kind and encouraging. So it was all possible because of the support from my college, and I'm very proud of that. Now I venture into my official duty of thanking the persons who made this function very special. I start with Dr. Gifty Umman Madam, Associate Faculty, His Highness the Maharaj Government Law College, Ernakulam. This is only an informal thing for me, because me and Gifty ma'am, she's my teacher during my college days. For 5 years, I was mentored under her. So it is, I feel very happy that even after passing out my college, I get an opportunity to share a venue with my former teacher, and I also get an opportunity to thank her for being there in this function. Thank you so much, Gifty ma'am. Next, I move on to the principal of the government, His Highness Government Law College, Dr. Bindu M. Nambiar ma'am. As I told before, now also she is smiling. When we came there also, she was smiling. When I was in the college also, she was smiling. This smile gives immense positivity to us, immense motivation, because it kind of gives a responsibility to us, so that she can maintain a smile before and after the competition. It's a huge responsibility. So the positivity and the encouragement and the support Bindu Nambiar ma'am has given throughout the competition, from the first edition to the second edition, we are totally delighted, and we sincerely thank you for all your support, and we also seek your support in our future endeavors also. Thank you so much, ma'am.
Thank you, Akhil.
Now I move on to the very special person of today's function, Honorable Justice Mr. Devan Ramachandran sir, Judge High Court of Kerala. As Atmaja mentioned in the opening part, a pro-public judge, and at times I take the privilege of saying people when I talk that I also graduated from the same law college from where Justice Devan Ramachandran has graduated, and it gives me immense pleasure to say that. And I vividly remember when I was studying in law college, I think in 2017 or 18, Justice Devan Ramachandran sir has visited the college in connection with a moot court function, where his lordship stated that my alma remains here, and each time I come, I rejoice the same. And I think his lordship never misses an opportunity to come back to the college to see that his alma always remains here. This time also, he has taken this opportunity to come back to this college and contribute. And I also recollect what one of my professors told when I was passing out from my college, SS Girichangar sir. See, once you pass out from the college, it is your duty that you give something back to the college. So me and Gajendra take encouragement from Justice Devan Ramachandran sir, Justice Jayasankar Nambiar sir, Bechu sir, who come back to the college to contribute to the college. So this time also, his lordship was keen enough, without much hesitation, amidst his busy schedule, he could find some time here. And as a young member of the bar, I also admire Justice Devan Ramachandran sir for his judgments, because I only got few opportunities to argue before him. His lordship is more familiar to me through judgments, which is omnipresent with judicial prudence and and what judicial prudence and legal prudence, I would say. And one of my judgments, which I could recollect right now, is with regard to section 92 of CPC, with regard to whether the additional court can grant a leave for prosecuting a suit. It was enlightening as a junior lawyer as to how to bring out, how to differentiate certain nuances of law. So though there are so many judges, though there are so many judgments which have helped the citizenry on the legal aspect, this one was very special to me. So at this juncture, I would also like to disclose that the same to you, because I never had the privilege to argue before your lordship. I have represented short matters, but I didn't get an opportunity to argue in length and breadth. So I admire your lordship through the judgments. And thank you so much, sir, for being here in this competition, because the peculiarity of this competition, I take pride in saying that the peculiarity of this competition is that the global trajectory it shows, the panel itself, 3 judges from 3 different continents is judging. One is from Europe, Africa, and Asia. This itself shows the global trajectory the competition is giving. And also another peculiarity of this competition is fairness. Why I say? Because prior to the competition, we give a training program to all the participants so that everyone get an opportunity to perform well in the competition. And at this juncture, I thank the Mediation Academy based in UK for providing a free training course, and also Bryan sir for giving a free training course for all the participants prior to the competition, which gave them equal opportunity to compete with all other teams. So thank you so much, Devan sir, for being with us in the future endeavors. Also, we look forward to your presence in all our endeavors. Thank you so much, sir. Now I will move on to Dr. Sherif Elnegahy, Chief Judge, Cairo Economic Court, Egypt, and Mediator of Global Mediation Panel of the Office of Ombudsman for UN Funds and Programs at United Nations. To my knowledge, sir is having a very tight schedule. Admit that he has found some time to contribute towards this great initiative. That itself shows how much commitment he has towards the area of mediation. Though he was a judge in this finals panel, he was constantly updating or seeking update about the progress of the competition. I think his presence in the judging panel has enormously contributed to the way this finals have been conducted. Thank you so much, sir, for being with us. Now I move on to the faculty coordinator who was with us. That is also very informal for me, because mine, sir, Justice Main Abubakar, sir, who was mine, sir, for me, because he was also one of my mentors during my college days. And it was very easy to have a communication with mine, sir, because he had trust in us and we had trust in mine, sir, as well. So there was no much confusion with regard to how the competition is going to be conducted, and his experience has enormously contributed to the smooth functioning of this competition without any error. Thank you so much, sir. Thank you so much for being with us. Thank you so much. Now I take this opportunity to thank the key people of this competition. It is not me. It is not Gajendra. Though Gajendra is the patron of this competition, me and Gajendra have only supported the initiative of the students. It was a competition which is organized, conducted, and everything was done by the students of Government Law College and also the Lex Erudites team, because it was their dream, it was their pain, it was their sweat for the last 3 days, which have exhibited excellence from students of different universities, from different jurisdictions, from different colleges. So I take this opportunity to thank each and every one of them, and it would be unjust if I don't say the names of these people, because they are the persons who were behind this competition. Firstly, I would like to thank Shivadat Madhu Menon and Arun Vaidyanathan, who are the founders of Lex Erudites. Lex Erudites. They are the founders of Lex Erudites, and it is through them the Lex Erudites was found, and it was their vision which was made a reality through the Government Law College. And also, when I say Lex Erudites team is incomplete without one person, that is Professor Bryan Clark, sir, because the Lex Erudites would not have done this competition or achieved this competition for the second time without the support of Professor Bryan Clark, sir, because he have put so much pain into it, contributed so much time into it, because we were compelled to go into so many discussions and video conferencing and admit, and there was a difficulty because there is a difference in time in India and UK. However, overcoming all those things, because I would like to thank Bryan sir as a part of Lex Erudites. We want to take that pride. We want to take that pride and say that Bryan sir belongs to Lex Erudites. He is also the one of the member of your advisory panel, and he's not only advisory panel, he is a elder brother to me, elder mentor, and an elder friend. And that kind of connection is there between Lex Erudites and Bryan Clark, sir. So I would like to thank Bryan Clark, sir, for being with us. And I wish that Bryan Clark, sir, will be with us in the future endeavor also. I thank you so much, sir, for being with us.
Thank you so much. That's so kind of you. And yeah, that means a lot to me. Thank you so much.
And coming back to the other members of Lex Erudites, who are the senior partners, Lakshmi Nantana is also from the Government Law College, but who's also a part of Lex Erudites. Senior partner Atmaja Menon, senior partner Amrita Nawada, Ellen Maria Karthik Menon, Maithili S. Nath, Radhika Prasad, Joanne Matthew, Adida Dhyan, Govind K, Vahini Parameshwaran. And I should also congratulate my team of Lex Erudites, or our team, because these students are from different colleges spread over different states in India. They have come together and made this competition possible. That is something which I admire, because different colleges, different culture, different students, they are not from the same college, but however, the skills they have acquired from different colleges have come towards one point, and that is the reason why this competition has become a success. So I congratulate and I thank each and every one of you who are the backbone of this competition. Thank you so much. And also the student coordinator of the government, His Highness Government Maharaj Government Law College, Aisha Ruswana, and his team of volunteers, her team of volunteers, who was throughout with us. Without their support, we couldn't have done this. She was also involved in all the activities with regard to the conduct of the competition. And we thank each and every one of you for your kind contribution towards us. And last but not the least, I would like to thank two sets of people. One class is the sponsors of this competition, because they have contributed financially for the conduct of this competition. Because without that also, this competition would not have been possible. And I would like to read out the main sponsors of this competition. Advocate Saibi Jose, SJK Legal, S. Srigumar Associates, Advocate Philip T. Verghese and Associates, Sanjay and Parvati Associates, Men and Pai Associates, Advocate P. Balagopalan from Ottapalam has contributed towards the memory of his father, KMC Kurup, former chairman of Bar Council of Kerala. Without their contribution also, this competition would not have been possible. Last but not the least, I convey my gratitude on behalf of the college and Lex Erudites to all the participants who have made an effort to come and register for this competition. And I wish all the best for all the competitors, the winners, the runners-up, and also those people who could not make it to the semi-finals. And I believe that the winners here in the last year were eliminated in the prelims round itself, I think, the Thodupuzha College. So that gave me immense pride because their persistence, because they decided to come back. We will not give up. And last time they were eliminated in the prelims round, and this time they have bagged the title. So that is that should be the approach towards competitions, because at one point of time I was also on the other side going for competitions and I was not winning anything. And Devan sir, who was also a professor of Government Law College, I went up to him and said that, see, I'm not going for competitions because I'm not even qualifying the prelims round. So what is the point in going for competitions? Then Devan sir told me that, I still remember, see, go for it. Someday you will win. Someday you and Gajendra would win. And we again went for competitions. And there is one time that there also I recollect what Girisankar sir said. One time you taste success, you cannot go without tasting it. So this time Cooperative Law College have tasted success. Next coming years, other law college should also strive towards tasting success. So next time also, we all wish that all the participants of this competition come back to us, compete, and make this competition a great success. Thank you so much, everyone, and thank you, Karthik, for being a wonderful MC, for being with us, and thank you so much. Back to Karthik.
Thank you for the opportunity, and I think sir for being the backbone of the competition. Thank you so much for all this initiatives. Without your guidance, it would not be possible for us to conduct such an event. And I hope that through the journey of these 3 days, the participants as well as the judges were able to explore the possibilities. And with the constant support and guidance in the future, Lexiprise will be able to climb greater heights. And we look forward to hosting you next year. Until then, we will sign off from there. Thank you so much for being a part of the Valedictory function. And we all hope you all have a good.
Thank you.
Thank you.
Thank you all.
Thank you, sir.
I would also like to congratulate to the winners and the best mediator winner. Congratulations.
Congratulations.
I'd also like to congratulate both of you.